Hi, my name is Michael Santos, and I'm with Prism Professors. Every day we strive to create new content that will help justice-impacted people at various stages of the journey. And one of the discussions that come up frequently is the pre-sentence investigation report. This is a document that the judge will use to learn a little bit more about the individual more than the criminal charge. Now, it's our belief that an individual should thoroughly prepare before participating in a pre-sentence investigation interview. They should understand what excellence looks like, and they should really invest the time and the energy to prepare themselves well. So in this webinar, what we're going to do is record the entire kind of the process, or really just tee you up. The more you learn, the more confidence you're going to have that you can work through this effectively. We always encourage somebody who's going through a pre-sentence investigation to invite their attorney to be with them. But I think it's also incumbent upon every individual to prepare himself well before the pre-sentence investigation interview. And one way of preparing is to kind of see what is the end result of this document. So why don't I go ahead and share my screen right now, and I will reveal to you an actual pre-sentence investigation report. Now, I have redacted the report to remove any identifying information because that's not really what's relevant. What is relevant is that you can see the report. And you see at the top caption there, it is produced by the district court. It's going to be produced by a federal, if you're in the federal system, by a federal probation officer. And what will happen is the federal probation officer will schedule an interview time, but by the time the probation officer meets with the individual who is going through the process, the probation officer already will have met with the prosecutor and gotten the prosecutor's version of events. And so this is the report that he will complete at the end of the entire process. So it looks something like this, where it's written specifically for the judge, because remember, the probation department is part of the judicial branch of government. It reports to the judge. The probation officer is going to be assigned to the case by the U.S. District Court. And the purpose of this document is to help the judge get a little more understanding about the person. And so you want to really understand that so that you can prepare more effectively. In fact, I want to create this graphic. I don't know why it doesn't show up on the screen. Let me see if I can do this, move this up here a little higher. Yeah, there it goes. So this is about the pre-sentence investigation. I just want to make sure it's showing on the screen, so if somebody's watching this on YouTube, they can see what we're talking about. So you'll notice on the report, it will include in there the offense. Okay, what is the offense? It's going to identify that offense. It's going to identify some of the information about the individual. It's going to have identifying information of when the report was prepared and revised. And you can see this is a 22-page document. It goes on at the top of each page. It'll have the case number. I've redacted a lot of the identifying information because, as I said, that's really not necessary. What is necessary is you can kind of follow along here through this screen and see what does the finished document look like. It includes related cases, and then we move on to the next page here. And you will see that it even includes an image of the person, the identifying information such as the date of birth, the age, the race, the ethnicity, the gender. It'll include the person's social security number, FBI number, U.S. Marshal's number. And notice that I left the last 3 digits on there. That's also the BOP registration number, is the U.S. Marshal number. And those last 3 digits, 054, that indicates the judicial district. 054 happens to be in the Southern District of New York. There's alternate IDs and ICE numbers and educational levels. So it's providing all of this really static information from your past, including your legal address, your alias. And a lot of this information can be used on the downloaded from PSR. So make sure that you're aware of how to where this information is going to be used. It's not only going to be used at sentencing, it is also going to be used in the Federal Bureau of Prisons, as it says. And look at this information here: restrictions on use and redisclosure of pre-sentence investigation report. Disclosure of this pre-sentence investigation report to the Federal Bureau of Prisons and redisclosure by the Bureau of Prisons is authorized by the U.S. District Court solely to assist administering the person's prison sentence. Okay, and other limited outsourcing includes deportation proceedings and so on and so forth. What else does it say here? If this presentation investigation report is redisclosed by the Federal Bureau of Prisons upon completion of its sentence administration function, the report must be returned to the Federal Bureau of Prisons or destroyed. It is the policy of the federal judiciary and the Department of Justice that further redisclosure of the pre-sentence investigation report is prohibited without the consent of the sentencing judge. So that's one of the reasons that I redacted all of this information, so that you can't identify anything. It's just, I want to provide information for people to better prepare themselves for the journey ahead. So this is giving information on the indictment, on where it happened. It's going to identify the what do you call it here? The statutes, and those statutes are, of course, just legal jargon that have a lot of influence on the sentence length that is eventually imposed. You can look through the document, and they're all enumerated. All of these things are important in the designation process of the person going into the Bureau of Prisons. They are important for identifying whether the Bureau of Prisons is going to look at this to see if there are related cases, so that they separate people from serving time in the same place. The offense conduct, it's going to identify the offense conduct. It is going to really just document the entire process. Now, a lot of this information comes from the prosecutor because there's already been a finding of fact. None of this is reported until there is a guilty plea, but there is going to be a series of information that the probation officer is going to collect. It's going to have in here a section where the probation officer is recommending what guidelines apply based on the conviction. So a person really should spend time learning to understand more about what this looks like. The person should understand, how is this document going to influence the rest of his life? And so the more information, the more a person understands about this process, the better the individual can prepare. So I'm going to provide a link to this document, just making sure that everything has been redacted, so that there's no identifying information, but because this is really just a tutorial on what should somebody understand about how this is going to influence his life going forward. And so how does it get presented? Well, it gets presented depending on which district the person is in. There's one from the Southern District of California, right? There's one, I have a sample here from the Northern District of Texas. These are blanks. So if somebody is convicted of a crime in federal court, the probation office is going to send this package of documents to the attorney, and the attorney will give it to the individual. Hopefully, the attorney will be able to get the form in some type of a fillable form, so the person can just type it. But if not, the person can simply work through it by hand and handwrite the work. In this era of a digital time, it's easier to type on a computer, at least for me. But let's go ahead and work through one here from the United States District Court, and I think this is from the Southern District of California. So I'm going to scroll through it, and you can see it's a federal probation system form, and it says the judge has referred your case to this office. He wants to know about you and how you became involved in the case. The information is necessary to assist him in reaching a decision. To help us with our pre-sentence report, please furnish us with any of the following papers that pertain to you. And so your job is going to be to gather all of this information here: the birth certificate, school diplomas, proof of residence, draft registration card, right? Everything you see here on this document. And this one is important, high school diplomas, because good time in the Bureau of Prisons is directly related to what's on this pre-sentence investigation report. There's also an information here on immigration status. That's also important to the designation process, because somebody who is not is a U.S. citizen may be subject to deportation, and the Bureau of Prisons may consider that when it comes time to designating the individual. So this is what they're going to ask you in the beginning, to gather that information. Again, you may be listening to this on YouTube, but you can always visit Prison Professors. I will be publishing this document and webinar or video on the before sentencing tab under the resources at the top of our website. We have free resources. And under before sentencing, this is information that we would encourage people to learn and understand. So you can scroll through here some more and see, well, now what is the worksheet for the pre-sentence investigation report? Some of this you may not know the answer to. And if you don't know the answer, you would just simply be honest and write not applicable, or I don't know, maybe IDK. But the more you put, the better you're going to help yourself and help the probation officer prepare an accurate report. So you fill out what you can, you leave blank or write in there, I don't know, or not applicable in different areas. So it's really quite simple, where you're just filling out this really static information here. There's nothing you can do to change the past, but you can influence the future. And we will be talking about that as we work through this document a little bit further along. So let me just scroll through here, and here's kind of an important part where it says the offense data. What are the charges and the convictions? Again, a lot of this will be supplied by the prosecutor, who will insert this kind of information for the probation officer, including, but you may have some as well. You may not know the minimum maximum statutory penalty. Remember, a statutory penalty is what Congress has mandated can be associated with a specific offense. It's different from the federal sentencing guidelines, which are advisory and which the judge will consider at the time of sentencing. There's a section here for detainers. If a person has an open case in any other jurisdiction, whether state, county, or even another federal case, there's a likelihood that there could be a detainer. It's in every individual's best interest to try and resolve that detainer as soon as possible, because if there is a detainer, the Bureau of Prisons will consider that in the custody and classification system, which could result in confinement in a higher security facility than is necessary. There is a policy in the Bureau of Prisons that the Bureau of Prisons talks about in their policy statements, called the Interstate Agreement on Detainers, where somebody could simply write a letter to, if there's an open case someplace else, explain the situation, and hopefully you can get the other case running concurrently with the current case, so that there would not be a detainer. Hopefully you can get it expired while you're in the federal system, because if you have a detainer, it's going to influence certain aspects of the bureau of your time in federal prison, including whether you are eligible to participate in some beneficial programs. There's going to be information here about co-defendants, which the Bureau of Prisons will consider, because typically the Bureau of Prisons does not like to put people in the same case in the same institution, because there could be potential problems with that. If that's not a problem and you have a co-defendant that you want to serve time together, you may discuss that with your attorney and see if your judge can make a statement of that about the need to be together in the statement of reasons or in the judgment order itself. The Bureau of Prisons will consider that information. And and you want to be just conscious that these are things that influence time in prison. If there are related cases, you want to use that information here. You want to be aware of that and do what you can to influence this in the most favorable way possible. There's a plea agreement here, which is basically where the standing of the case is. You may need help from your attorney on this. The offense conduct, this is going to be important, where you notice that they talk about the victim. A lot of times people going into the system want to see it from their perspective, want to try and argue from their perspective, but it's always best to try and put yourself in the perspective of the victim or the other stakeholders of the case. Try and understand how are they looking at this, because that is how the judge will be considering this information at sentencing. And it would be wise for somebody to be thinking about that early. If you haven't seen the interviews that we've done with federal judges where we've spoken about the importance of this, I encourage you to look at our subject matter expert page. Again, that's available at the top of our website. There's a link there that says resources. Drop-down menu comes up, look for subject matter experts, and you will see the interviews we have done with federal judges, so you know what they say. And if you click on the link, you will also see a page where there's a drop-down menu. A page where I'm actually linking to the specific questions that I asked the judge and give a summary of the judge's response. But we encourage you to watch the video and draw your own conclusions on why it's so important to prepare for this pre-sentence investigation report. This is a big segment here called acceptance of responsibility. It says the defendant's statement regarding the offense. Notice there's just a small block there of information. We would encourage the individual to try and influence what goes into that block, because it does show up on the actual pre-sentence investigation report that you would see later. So the more detail you can provide, the better you are going to influence the process. Not only at sentencing, but also while you're going through the Bureau of Prisons, and also when you're arguing for a higher level of liberty while on supervised release. You want to provide as much information as you possibly can to help people understand who you are, how you got involved in this offense, what you learned from this process, how you identify with victims, what you're doing to make things right, why the court can understand that you're not going to have further problems with the criminal justice system, and really how you're going to make amends. The more work you do on populating this information, on really helping the judge get to know you, the better off you're going to be. That's one of the things that judges have told us, is that a lot of times they sentence somebody and they really don't know who's standing before them. They only have the prosecutor's version of events. And the judge wants to know a lot more. The judge wants to know about your background, about your influences. And so we would always encourage people to learn about best practices and then invest the time and the energy to create a document that will help the court get to know who you are, what led you here, what influenced you, how you identify with victims, and most importantly, what you're doing to make things right. Don't be the kind of person that talks about what you're going to do. Really build a record showing that you understand the gravity of the situation and how you are doing more than talking about being sorry. So here you're talking about the defendant's criminal history. Well, there's nothing a person can do to change that. This is just factual. If you've got a criminal history, it's going to show up here, and you want to be honest in filling out to the best of your ability. You may not know the date the sentence was imposed, but I do think it's important to reveal what if a person has a history with the criminal justice system. If there are pending charges, a person would want to document that information as well. If there was a sentence imposed, you want to be honest. And all of this is also important for you later in the event that you want to apply for executive clemency. This document that you're creating lives with a person throughout the journey. So the more a person reveals, the better off a person is going to be. That's my view. But of course, you could check with your attorney and see what your attorney has to say. You're going to want to list all of this information regarding your housing, your support system out there. All of this could potentially relate to your release plans, and that can have an influence on your eventual transition to home confinement. And again, I would encourage you to watch the videos on our subject matter expert page. Again, that appears at the top of our website at Prison Professors, where you will see us interviewing the former leaders of the home confinement system. The more information you provide, the more effective you are going to be to advocate for yourself. Because once you go beyond sentencing and you no longer have a defense attorney advocating for you, you've got to advocate for yourself. And we always recommend that a person develops really strong tools, tactics, and resources that will help them advocate for themselves. This preparation for the pre-sentence investigation report is part of that experience. So all of this you would want to include. If you don't have enough room, create this as part of your personal biography or your narrative or whatever it is you're including. Notice there are questions here about substance abuse and alcohol and so on and so forth. It's very important for people to understand this segment of the pre-sentence investigation report, because this is the area where somebody may qualify for programs inside of the Bureau of Prisons. Sadly, there are a lot of people that are under the mistaken belief that admitting their history with substance abuse or their history with alcohol abuse is going to make them look even worse in the eyes of the court. But nothing could be further from the truth. Judges have statistical data, and the system produces statistical data that show how alcoholism or substance abuse really influences thinking patterns and leads people into making decisions that may be aberrational or outside of the scope of their character. And as they say in the Alcoholics Anonymous or someplace like that, really the first step is to admit your name. My name is, so on and so forth, and I am an alcoholic. And sometimes it takes a person a long time to get there. Unfortunately, when you're going into the criminal justice system, you don't have a long time to get there. If you don't do it at the pre-sentence investigation report, that could preclude you from access to beneficial programs that can have a huge influence on your release date in prison and a huge influence on your level of supervision and your access to liberty when you come home. So my recommendation is you do a lot of research on programs in the Bureau of Prison, particularly the residential drug abuse program, because that has kind of a nasty connotation, the name drug abuse. People don't want to admit they are a drug addict or they're drug abuse or they have alcohol as a problem. Nobody wants to admit weakness. But part of the whole process of corrections is really about healing and about doing better and wanting to do better. And, as we've learned from philosophers that have lived for thousands of years, the first step in doing better is to admit it and acknowledge it. I can tell you that there are many people in federal prisons across the nation that really regret the way they responded to these questions, not being honest, because that their failure to admit their substance abuse, and this is all self-reported, but a failure to admit it precluded them from participating in programs that could have a very beneficial impact on them. As when I interviewed the former director of the Bureau of Prisons, and you can see that at the top of our list, again, under subject matter experts, he really explained the process of corrections. And the process of corrections is, to use his analogy, if somebody starts at the worst place, the most secure place, a high security United States penitentiary, the science of corrections is to move him better, right? From a high security penitentiary to a medium security, to a low security, to minimum security, to a halfway house, to home confinement, to supervised release, and on to a law-abiding contributing life. Well, you want to be thinking about that as you're working through this pre-sentence investigation report. and help all stakeholders in the system at all stages of the mitigation arc understand who you are. So this document really provides the historical record of how you started, and you want to just show continuous improvements, eventually preparing a successful reentry plan. That's what you want to culminate with, a successful reentry plan. But that reentry plan should start today. We use this analogy. It says, when's the best time to plant an oak tree? And the best time, of course, is 20 years ago. The second best time is today. If you had prepared for all of this before you entered the criminal justice system, you may be far better off in being able to prepare to avoid a criminal justice problem. But all the way through this, there's all types of opportunities to begin a mitigation strategy. I just think that the pre-sentence investigation report is one that very few people going into the system understand. For example, we're here now at they call it the defendant's physical condition. If a person has any type of ailment or medical condition, they want to document this because it can influence your housing situation. It can influence the jobs that you're assigned while you're in prison. It could limit your exposure to more harsh conditions. It could put you on a pathway to get better treatment, to get better access to programs. But if you don't know the relationship between what you're putting down on this document and your future, well, then you're not in as strong of a position. If you could think back to many of the people going into the criminal justice system may have prepared well to go to college, and they hired coaches or SAT people. I can tell you everything that our consulting business sells, you can get for free right here just by learning this and spending the time yourself to do the research and figure out, okay, how does this apply to my life? And that's what I'm telling you right now. All of this information should not be done haphazardly. A person really wants to prepare long before he sits down with a probation officer so that he can document all of this mental and emotional health, because it's going to qualify people for various programs. Those programs can have a direct influence on when a person transitions to home confinement or whether a person goes into prison at all. If you look at the interviews we did with federal judges, there's a lot of information that they consider, but they say a lot of times people come poorly prepared. They have not prepared themselves well before the pre-sentence investigation interview. So you want to document this information. What does this question say? Have you ever had to lie to people important to you about how much you gambled? Have you ever felt the need to bet more and more money, right? I mean, that would imply a weakness. That's a weakness of character, a weakness of a person's critical thinking skills, and somebody may not want to acknowledge it. But if a person acknowledges it, there may be a program to help, and that program may be beneficial to somebody while they're going through the Bureau of Prisons. So learn about all of these the relationships between the pre-sentence investigation report, such as here, where it's talking about substance abuse, and what you write here, because this becomes a living record, and it will influence a person's life not only at sentencing, but also when a person goes into the criminal justice system. So this is actually what the form looks like. You can see I'm scrolling through it, and of course I will provide a link on the webpage that accompanies this video so that you can download it. If you have not received this form from your attorney yet, you should know all of this information that it's going to ask. And everything you put here has legal implications, as well as I don't know if I would call it program eligibility implications once somebody goes into the prison system. It has legal implications because it's a federal form, and there are laws that pertain to federal forms, such as Title 18 USC 1001. So this is all self-reported, but the government is going to expect people to report honestly. And so I want you to to download this, to really think about it, to do as much research as you can to understand how are these implications going to influence me when I'm going through the Bureau of Prisons, or when I'm going through supervised release, or when I transition back to society, or, at sentencing itself. So there's a lot of ancillary information available on our websites that you should be looking at as well, including those interviews I did with federal judges. There's all types of questions here on financial information. The one thing I really want to caution everybody about is being honest and truthful when it comes to this information, because if the probation officer concludes that you have been dishonest, or either by telling a lie or by omission of information, that probation officer could potentially recommend an enhancement at sentencing for obstruction of justice. It could also lead to new criminal charges. So make sure that you learn this document. If you're watching this on video, you can see as I scroll through it here, I think that you'd have the ability to scroll through it slowly and really comprehend everything that is on these forms. It gives you instructions on how to calculate cash flow and financial statements and that kind of information. But anybody who has a basic understanding of budgeting and so on and so forth can fill this document out. It's not something you can fill out in a half an hour or an hour. I mean, it's going to take time. As you can see, there are 49 pages in this sample that I'm going to provide for you as a download. So you should expect to spend several hours getting the information you need, but it's a great investment of your time, because if you do this well before you have your pre-sentence investigation report, you are going to show your probation officer a lot. You're going to show the probation officer that you are doing the best that you can to be honest, and you really want to make the probation officer's job easy. You want the probation officer to be your friend. You want the probation officer, he's not going to be your friend, but effectively I'm saying you want to be seen as somebody who is not hiding information. All of that can reflect well with both the magistrate judge, the U.S. District Court, the Bureau of Prisons, the probation officer that you're going to meet years into the future, your efforts if you're going to pursue executive clemency. It's there. This is, what is this here? This is a sample. Say amended general in the matter of adoption of standard conditions of probation. Oh, this is what standard conditions of supervised release are going to look like, right? You want to get to know all of this information as early as possible, because the more you understand, the more you can differentiate yourself from everybody else that appears before that court. Okay? You definitely want to be thinking from the perspective of stakeholders who are looking at, what does everybody want? Everybody wants the highest level of liberty at the soonest possible time. But as the famous basketball coach, forgot his name right now, said, everybody has the will to win, but not everybody has the will to prepare to win. Make sure that you prepare yourself, and before your pre-sentence investigation report, the more you prepare, the better off you are going to be. And that's really what I wanted to share with members of the Prison Professors community today. If you have more questions, I encourage you to look at our subject matter expert page, watch the interviews that we have done, even with Chris Maloney, a former chief of probation, watch the interviews that we have done with federal judges, watch the interviews we have done with retired members of the Bureau of Prisons who really provide a tremendous amount of information. And the more you get that information, the better off you're going to be. So I'm going to sign off right now. Thanks so much for being a part of our community at prisonprofessors.com. If you want more information, I scroll through the website because that's really how I try to provide it. Thanks so much for being a part of our community. Subscribe to us on YouTube or iTunes if that's where you're getting this information. Thank you. Bye-bye.